on behalf of the Digital Chamber, we've been advocating in the amicus briefs that it's important for the courts to look to the existing law and how we may apply to the transaction that's subject to investment contract. The tokens themselves may not be securities. So we're starting to see the courts one by one adopting some of that existing case law. And it'll be interesting to see how that develops across some of the other litigations that are currently pending.
Welcome into the Thinking Crypto podcast. I'm your host, Tony Edward, and with me today is Lilya Tessler, who is a partner and head of the FinTech and blockchain group at Sidley Austin LLP. Lilya, great to see you again.
Great. Thank you for having me here today.
Lilya, the last time we spoke, the market was in a very different place, and boy, things have changed significantly. Crypto is appearing everywhere. TradFi has entered the market. Politically, crypto is having influence there. And there's been a lot of lawsuits back and forth between different government agencies, especially around the SEC. I would love to kick it off by starting with, what are your thoughts on how crypto has grown significantly and the impact it's having on politics and elections?
Yes, definitely. So largely crypto and blockchain is a bipartisan issue, and it's playing a very active role in the current upcoming elections. Many voters care about this topic, given the mainstream adoption of crypto and blockchain over the last several years. We're also seeing Congress conducting hearings on the topic, everything from kind of what regulations exist, what ways can the technology be used across different verticals. We're also seeing congressional candidates discussing their views on the topics, and even presidential candidates weighing in on these issues. So it's very interesting to watch and see how much of a mainstream topic this is.
Yeah, I think back to earlier this year, and I don't think anyone saw it coming, but then the political winds just changed, and Donald Trump was a part of that. But as you mentioned, members of Congress were like, we got to get some legislation through. And then I think we saw more Democrats started embracing the technology. It's fascinating. So I guess crypto has gone mainstream. It's become ubiquitous. I mean, what are your thoughts on that?
Yeah, definitely. And I think I've been practicing in this area for more than 8 years, and have seen it from kind of conceptual use cases that may yield adoption to actual companies implementing it across different industries, seeing different investors from investment funds to big major banks, broker dealers implementing the technology or investing in different types of crypto assets to extent their securities. So it's definitely seen a much broader adoption, and everyone's asking questions about it across the board. So it's very exciting.
And has your firm seen an uptick in clients and people looking to, like you said, make sure they're doing the right things legally, they're within the guardrails? Have you guys seen a surge in business?
Yes, definitely an increase. And I've been advising clients for many years, and it used to be that I'm advising them on how to implement different products and services, starting from early stage companies developing this technology. But now we're seeing an uptick in bigger financial institutions, industries, public companies seeking our advice on how they can get in this space and utilize some of the benefits of this technology. So definitely an uptick in proactive regulatory and transactional advice, but also in the recent kind of increase in enforcement and litigation, we're seeing advice on how to navigate the current enforcement environment, but still be able to adopt and use this technology.
Yeah, for sure. And speaking of enforcement actions and the league uptick in legal cases, it's pretty crazy out there. I mean, you have the SEC, of course, going after different projects and suing different exchanges. But now the industry, I think, the folks are coming together and countersuing the SEC, saying, hey, we don't, the rules of the road are not clear. We need guidance. We're going to fight back in court. I would love to get your perspective on that. Have you seen anything like this in other industries?
Yes, I think it's definitely unique here in seeing so many SEC enforcement actions, especially in a space where there's not as much rulemaking and guidance. And I think that's where we're seeing a lot of pushback by the industry and the proactive litigations. I think a lot of the players want to comply with existing regulations and guidance, want to come in and register, but they're seeing challenges and hurdles being put in their way. And so as a result, we saw a number of years ago, the SEC filing actions against protocols for selling tokens through unregistered securities offerings. Now we're seeing the cases expand to include unregistered broker-dealers, exchanges, and clearing agency allegations. And now even certain products, like we're seeing cases for unregistered securities activity in the staking space, or a non-custodial wallet, which is technology, being alleged to be unregistered under securities laws. So it's really expanded in terms of the scope of the regulatory actions in this space, and not being offset as much with proactive guidance and rulemaking.
Maybe we could touch on a high level on some of the different cases that took place. The last time we spoke, your firm did an amicus brief, I believe, with the Digital Chamber on behalf of Ripple with regards to the XRP lawsuit. And since then, Judge Torres ruled that XRP intrinsically is not a security, and secondary market sales are not securities. Now, the institutional item is still being litigated between the SEC and Ripple. But what are your thoughts on that? And in conjunction, just last week, they dropped the case against Stacks, the layer 2 for Bitcoin. They dropped their investigation against Ethereum. Is there some sort of capitulation here?
So certainly we're seeing the courts looking at the existing law and applying that to the fact patterns in these various cases. And this is something that on behalf of the Digital Chamber, we've been advocating in the amicus briefs, that it's important for the courts to look to the existing law and how we may apply to the transaction that's subject to investment contract. The tokens themselves may not be securities. So we're starting to see the courts one by one adopting some of that existing case law. And it'll be interesting to see how that develops across some of the other litigations that are currently pending.
Now, from a legal perspective, and I remember talking to SEC Commissioner Hester Peirce about this, that she's trying to get the agency to not think of the oranges, if we use the Howey test as an example, that the oranges themselves growing on a tree or in the supermarket or in your house are not securities, but rather it's the packaging or the scheme that's put together here. Did the SEC go off base here because they didn't follow that theory, so to speak, or set up that, hey, these tokens exist, they're distributed globally on blockchains, but it's not that they're intrinsically a security, but rather are they being packaged and offered in a manner of a security? So do you think they completely missed the mark here with these digital assets?
I can't speak to kind of generally with respect to the SEC because it really depends on the case. What Howey is a facts and circumstances case and analysis. So it's important every one of these fact patterns is to look at how the assets are offered, and if there is an investment contract or is it a pre-sale of a commodity or a sale of a commodity. That's what oranges are, they're commodities. So looking at how they're offered and sold is an important component, at least initially. That's what Howey was about. It was an initial offer and sale of a security, and it did not touch on secondary trading. And what happens when those oranges are resold in the secondary market. And that's also at issue in some of the kind of intermediary exchange cases currently pending.
So I don't know if you saw last week, like Chair Rostin Benham, he testified and talked about 70 to 80% of the crypto assets in the market are not securities. So there seems to be this turf war between the SEC and the CFTC. Obviously, Congress is working on regulations with FIT 21 and so forth, which would give some more power to CFTC. What do you think about that dynamic and how that may play out?
Yeah, so FIT 21 is the market structure bill that relates to digital assets and how blockchain native distributed ledger tokens can be potentially issued through under investment contracts or otherwise, and provides primarily the CFTC jurisdiction over digital asset markets, but also allocates certain responsibility to the to the SEC as well. So a digital asset, if it's classified as a digital commodity under this FIT 21 bill, it's regulated by the CFTC if the blockchain network on which the digital asset relates is both functional and certified by any person to the SEC as decentralized, which is consistent with some of the guidance we've seen in the past from the SEC, some of Commissioner Peirce's proposed safe harbors that are out there. So it's a way to codify some of the existing guidance we've seen, but also provide a clear path to regulation or legislation in this area, and also give the CFTC's oversight over some of the digital asset marketplaces that currently don't have direct oversight because they're commodities exchanges that are not subject to CFTC jurisdiction.
One of the things the people in the industry are waiting for is for this Fit 21 bill to make its way to the Senate. Most likely it could be merged with Senator Lummis and Gillibrand's version. Do you think we see that in 2025, that and maybe whoever's the president, we don't know, but it goes through the Senate and makes its way to the president?
Yeah, so definitely something on the horizon, this bill combined with others, or we're seeing a lot of legislative bills that are out there that have a lot of industry support and are bipartisan support, which is important. They say most likely won't see anything before the elections this year, but certainly 2025 is a possibility. And this is much more of a topic that we're seeing at play across our various clients than we have in prior years.
Now, one of the things that has been a hot topic is SOB 121, which has some very strong guidelines as to what banks can do with crypto if they want to custody it. So it's a de facto ban, so to speak. You can't touch it. There was a repeal in the House and then the Senate, but then the president vetoed it. Any thoughts around that, and what might be the next steps, after Biden's veto and the failed vote in the House to repeal Biden's veto?
Yeah, so SAB 121 provides guidance for crypto asset custodians to safeguard customer assets, which includes, impacts to public companies, banks, and broker-dealers. It creates a different accounting standard effectively for crypto assets from traditional assets, some of which, and I testified to this at a House Financial Services Committee hearing last month about the fact that there should not be different treatment for tokenized assets that are different just because they're recorded on a blockchain. And I think it'll be interesting to see what happens going forward with this guidance. Obviously, it's still in effect because it was vetoed by President Biden, and there was not enough votes to repeal it. But it's still kind of out there, and seeing what will happen going forward will be interesting. I'm also hearing that there are discussions with some of the industry participant financial institutions on how to proactively get guidance on this topic and clarify some of the issues in the SAB 121 that are out there with the SEC.
So tell us about clients you're working with. Are some of them exploring tokenization, and are they coming to you for advice on the legal guardrails and guidelines and so forth that they need to adhere to?
Yeah, we're definitely seeing a lot of tokenized asset products. Certainly, one of the first and biggest areas is tokenized securities, traditional securities recorded on a blockchain ledger. In my congressional testimony, I used the example of tokenized private fund interests, which is a really good use case, and we were working a number of clients on that. We're also seeing tokenized treasuries, money market funds. A lot of different types of securities can use the blockchain ledger as the underpinnings of its share register, whether it's the primary record or it's a duplicative record. The reason I mentioned duplicative record is because the current regulations for intermediaries present certain challenges having the blockchain as the primary record until there's more regulatory clarity or guidance on that for the intermediaries.
Are any of your clients checking with you on legal advice for stablecoins? We've seen a rise in different stablecoin issuers, and it seems to be, one of the killer apps of crypto in addition to tokenization, but mostly around the US dollar, but any activity there?
Yeah, so definitely tokenization of any assets, especially in the financial services, like we're seeing tokenization of bank deposits, and I mentioned money market funds, but stable coins, definitely another use case that we've been advising clients, everything from securities laws, commodity laws, how the intermediaries are regulated that support the stable coins, maybe even products that may package and use stable coins in different ways. So there's a lot of different use cases for stable coins, and they're important in the blockchain infrastructure generally, because the blockchain, in order to get to instantaneous settlement, even like a traditional security with a payment mechanism, stable coins are, can move on the blockchain immediately, as opposed to traditional payment rails that may have a lag of day or 2 days for settlement, for example.
Hmm. Um, do you expect enforcement actions to ramp up post-election, or do you think, and this is a tough question because there's obviously the election coming up and we don't know who's going to be the president. We've seen some of these agencies act a bit they seem to be politically motivated to a certain degree. Um, or do you think, let's say Trump becomes president and we'll see a ramp down in these enforcement actions?
So I guess there are a lot of different enforcement actions that we may see. I think a lot of the current ones targeting compliance with regulations as opposed to fraud-related claims could subside depending on what direction the what direction the election goes.
Mm.
I think a lot of people in the market are watching to see what happens there, who's going to be potentially in the next chair of the SEC, and how that will be driven. I wouldn't say enforcement actions are eliminated. Certainly, compliance with securities laws is important, irrespective of what the political climate is. And the SEC has been focused on this area for many years prior to the current SEC administration. But it certainly may provide a path to some type of compliance or registration for some of the market participants out there if there is a change.
Hmm. Um, do you feel more, based on maybe the sentiment from your clients, that more of folks in the industry are not as worried or afraid about these enforcement actions anymore? I think a few years back, everyone was kind of remaining quiet. We're not going to countersue. We're not going to send any briefs, anything. We're just going to watch and see what takes place. But now it seems there's this proactivity from the industry. We're going to fight back. We're going to punch back against any type of overreach.
Yeah, and certainly we're seeing a lot more market participants and our clients going public with Wells notices, Wells responses, and the fact that they're one of many and aligning with their peers in the industry that also are navigating similar waters. We're also seeing, I think recently, the SEC sending closing letters that certain enforcement investigations have been completed without recommendation to bring in action. And that's being made public as well, which we have never seen in the past. So I think it kind of goes both ways, that this is all playing out in the kind of public very broadly.
Hmm. So what's on your roadmap for 2024 as it relates to crypto and blockchain? Is it just, continue to work with different clients, or are you guys looking to do anything new?
So I think certainly a lot of my work has been in financial services because the use cases have started in that area and some of these securities law issues that we're navigating. But we're seeing clients implementing blockchain technology across so many industries. And tokenization of real world assets is a trend we've seen and are going to see more of. And so we're starting to work with clients in other verticals, trying to implement this technology, figuring out what regulations exist in those industries that provide for the use of blockchain technology. How should they be, modified to extend some of those regulations do not allow for technology innovation such as blockchain? How should they, certain states or federal regulations be modified to provide for that? And I think that we'll see more of that once we kind of get through some of the securities regulatory issues to focus on real world applications and uses.
Hmm. Final question here, this is a complicated one, but it goes back to what I mentioned earlier about like tokens distributed globally, on the blockchain, on these networks that are decentralized, and people from all over the world can use these tokens. But in certain jurisdictions, like for example, Japan or Singapore and so forth, Dubai, they view them as virtual currencies. Now, here in the United States, we obviously the SEC views them a majority as securities. How does that play a factor in litigation and building a case and saying, hey, look, we're in the United States, yes, this market, and we don't have clarity yet, but around the globe, the majority of these countries are viewing these as virtual currencies.
Mhm. Certainly, in a number of our discussions, regulators, industry groups, we borrow from other countries that are ahead of the curve in terms of creating regulatory regimes that provide for virtual currencies and provide for different categories of tokens. A number of industry groups have been supportive of some type of sensible token classification system. I've worked with industry groups on disclosure regimes, irrespective of what the asset is, and what regulations they're subject to. There may need to be some type of consistent disclosure framework that purchasers, holders, investors, other, depending on the asset, need to know in order to make informed decisions. And so the industry is coming together on their own to kind of borrow from global regulations and non-US guidance to come up with frameworks that may work here in the US. So we'll be interested to see how all that gets developed.
Quick follow-up question on that. Any thoughts on the EU MiCA regulations? I don't know if you got a chance to take a look at those.
Yeah, so definitely the EU MiCA regulations are relevant. Obviously, I'm licensed in the United States and don't advise on those, but we have colleagues in Sidley's London office that are very close to some of those areas and advise clients across the UK and the EU on these issues. Some of those are directly what we're borrowing from, and some of the industry groups that I mentioned that are trying to come up with proposed US disclosure guidelines for particular categories of tokens. We've released publicly, a part of this industry group on a May 3rd event, proposed guidelines for discussion, and working with the number of industry groups now on how to get feedback and kind of reissue some of those proposed guidelines.
Yeah, that makes sense. Well, fingers crossed that we see some good things here in the United States in 2025 with Congress getting some regulations through to the Senate and then up to the president, whoever that is, and we can finally have some clarity, and maybe some of your clients and then just the rest of the industry can, be not have to look over their shoulder.
Yep, that sounds great. Looking forward to what's to come.
Yeah, for sure. Well, thank you so much, Lily. Appreciate your time.
Great. Thank you, Tony.